I recently read a decision by the judges of the Trademark Trial and Appeal Board, or TTAB, which chastised the attorneys for not following the proper rules to introduce evidence. They actually didn't introduce evidence in the right manner or at the right time in this case. And it reiterated, essentially, the importance of having experienced trademark counsel in any kind of case before the TTAB. A trademark opposition is the most common type of dispute before the TTAB. And a trademark opposition is when an application has been approved at the USPTO and it's been published in the public records, and then another party files an objection to it. They could file an extension first, but inevitably, if they file an objection, it then moves the file into the Trademark Trial and Appeal Board, and it becomes an opposition case. An opposition case is litigation before the TTAB that can take 2 or 3 years if fully contested, and it contains many of the same features as court litigation, from motions and briefs to exchanging documents and interrogatory questions. There can be depositions. So it is a complicated and lengthy procedure or litigation. And the most common issue being litigated in a trademark opposition is a dispute between two trademarks with whether or not there is a likelihood of confusion. That's where somebody would object to the application because they believe their brand's trademark is too similar, is likely to be confused, and that they have earlier rights to the trademark, either because of a prior registration or because they were using the name first and have what's called common law rights in it. And it doesn't have to be just a name. It could be a logo or another trademark, type of trademark, but of course it is most commonly over a brand name. So these procedures are quite complicated, quite lengthy, quite expensive, but a great majority of them are resolved before they get to the end. And the key in a resolution is leverage in negotiations. The key is experienced counsel to guide you through the process and to determine what type of a resolution might be possible and how to get there, if appropriate. A lot of times, in my opinion, a much better resolution could have been found if the party had used some experienced trademark counsel. Trying to go at it on your own with either the complex rules of the opposition or the challenging strategy of negotiating a resolution can be quite difficult.